Thank you.
Thank you, colleagues. Ms Jones, are you aware that law enforcement hasn't ground to a halt in Belgium, Bulgaria, Denmark, Greece, Latvia, the Netherlands, Portugal, Romania and Serbia, which are all countries that, according to your very helpful appendix to your submission, have some form of judicial oversight of telecommunications authorisations? Why do you think it would grind to a halt in Australia, and what evidence do you have to back that up?
Well, Senator, we've obviously been discussing this with agencies in terms of their operational experience of the importance of being able to access data information as quickly as possible, as early in the process. I note that you've listed a number of countries, but we've also looked at the experience in the United Kingdom, where they've recently had to look at the regime that they had in relation to warrants, because essentially their operational experience was that it became virtually unworkable, and that the number of successful authorisations, I think, were significantly reduced. And there was a report to the UK Parliament by the Interception of Communications Commissioner that noted that it was causing significant delay in the progress of many investigations.
Do you have any evidence in any of the countries that I just listed that law enforcement has ground to a halt, or that there's been actually any impact at all on the efficiency of law enforcement?
We haven't discussed with the specifics of those countries. Is there anything further you can add?
No, we'd have to take that on. We haven't engaged directly.
Because it's a pretty big deal to come in here and make sweeping statements like law enforcement will grind to a halt unless we're allowed to continue vast warrantless access of telecommunications data. It's a pretty big call. And you have no evidence that in any of those countries that has been the case.
We are focused on the experience in the Australian context, on talking with agencies in Australia, and this is an issue that we've discussed before the Parliamentary Joint Committee on Intelligence and Security.
Yep, but you're here now with us. What evidence have you got in the countries that either have a standing data retention regime or those in Europe that had one that was then annulled, so Germany being one example, of improvements to the rate of clearance of crimes? Is there any evidence from any country at all, actually, that you could point to where data retention has led to an improvement of the rates of crime clearance?
I think one of the challenges in that regard is the extent to which data as a single point as an investigative resource can be said by itself to improve clearance rates. And I expect you may have in mind a German report which suggests that there was a limited and perhaps what has been characterised as negligible improvement in clearance rates as a result of the introduction of data retention there. What clearance rates, of course, reflects is the extent to which the number of crimes solved as opposed to the number of crimes on hand. What data retention, what access to data does is to provide the starting point for investigations and allows them to proceed further or indeed to commence at all. And in that regard, while there is that German report, I think it was only a fortnight ago that German Chancellor Merkel indicated her intention to lobby the EU for a new data retention directive, noting the very significant importance of data retention from her perspective for German investigations.
You've still managed to avoid the question. You've got any evidence from any jurisdiction at all that mandatory data retention either reduces crime or improves the rate at which crimes are solved? You may not have it at the table, but anything at all that you could point me to?
The evidence in support of data retention is not cast in terms of clearance rates. It is cast in terms
or
of...
crime rate.
Or
crime rate. I'll take any metric you care to name.
So perhaps in that regard I could refer you to some of the evidence of the law enforcement agencies who appeared last Friday, and from an investigative perspective, it is the case that it is extremely difficult to be able to point to data as one point and one investigative tool having a direct and quantifiable impact in relation to the number of prosecutions and convictions. The way in which law enforcement agencies apply metrics to assess their effectiveness in their prosecution and convictions is not able to hinge back to a single data point. And so,
not about a single data point. The whole category of data retention or metadata access in general. It's the opposite of evidence-based policy. It's anecdote-based policy.
It's policy based on very strong advice from the agencies who have responsibilities in relation to law enforcement and national security. So,
Of course they want more power. It's your job and ours to balance that power against proportionality and whether it's useful or not. I'm just asking for evidence as to whether it's useful. All right, we'll move on.